The Supreme Court ruled in favor of your privacy today, deciding unanimously that police need a warrant before obtaining your personal information from an internet service provider. The ruling may require the government to rethink some controversial legislation. But as Marco McDermott reports, the case that led to the decision is a bit of a surprise.
It all started with a Saskatoon man who downloaded child pornography from the internet onto his computer. Police got Matthew Spencer's name, address, and telephone number from his internet provider, and he was prosecuted. Today, the Supreme Court ruled that the police violated Spencer's privacy rights because they didn't have a warrant to get the information. Civil liberties groups call it a victory.
We can't have unjustifiable intrusions into people's privacy rights by the state, and this decision recognizes that.
The decision says this is all about a reasonable expectation that what people do in their own homes, on their own computers, is private. And the disclosure of this information will often amount to the identification of a user with intimate or sensitive activities being carried out online, on the understanding that these activities would be anonymous. But police say getting a warrant for internet providers will add another hurdle to investigate those who are breaking laws.
I anticipate that the additional work, the additional warrant that we will have to write will add at least 1 or 2 days to our investigative process.
This decision shows the top court has a different view of privacy from the government. 2 proposed laws, including the cyberbullying bill, would make it even easier for police to get internet customer data. This privacy expert says the government may have to revise those bills.
It certainly gives real weight and additional credence to those who have appeared in front of the parliamentary committees saying, hold on a minute, you're not taking proper account of the privacy interests here.
Today, hints the government is listening. Justice Minister Peter MacKay said in a statement, "The Supreme Court of Canada's decision has clarified the law in this area. We will review this decision and respect the ruling." The Supreme Court allowed Matthew Spencer's conviction on child pornography to stand because police thought they were acting lawfully. But today's ruling puts forces across the country on notice. Next time, get a warrant. Marco McDermott, CBC News, Ottawa.